We've been talking about it for months, and now the Supreme Court is hearing Moore v. Harper, a case that centers around a once fringe theory that could change democracy as we know it. Of course, I had to bring back Judge Michael Luttig. He's a former federal judge on the U.S. Court of Appeals for the Fourth Circuit. He played a crucial role in the results of the 2020 election when Trump and his allies were attempting to overturn it, and he's seen as something of an expert on these matters. Judge, good morning to you. Thank you for being with us so early this morning. We appreciate your time as always.
Good morning, Ali, and thank you for having me with you today.
Judge, I want to ask you about the idea that you and others have referred to this as a fringe theory, or a theory that has no basis in reality. But those who propose it or advocate for it point to Article 1 in the Constitution, Section 4, Clause 1, which reads, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators." And proponents of independent state legislature theory say there's nothing here that says this needs to be subject to courts or judicial interpretation. Why is that not the right way to look at this?
Ali, it was a day of high constitutional and political drama at the Supreme Court, and the stakes for American democracy were palpable throughout the 3-hour-long argument. It's always perilous to attempt to divine what any one justice, let alone the Supreme Court as a whole, is thinking from the questions. But on rare occasions, it is possible. And I think that this Wednesday was such a rare occasion. To your specific question, that is what Article 1 says. The Constitution does empower the legislatures of the states to prescribe the time, place, and the manner of holding congressional elections. The petitioner's argument really boiled down to what they called the textual argument, that because the Constitution confers that power upon the state legislatures, then that power is plenary, exclusive, and there is no other state power that can be brought to bear on the legislature's decisions, such as the state constitutions as enforced by the state Supreme Courts, and or executive power, such as that would be wielded by the governors of the state.
And the governor of North Carolina has actually penned an op-ed to say he doesn't share that opinion. The argument Judge Ketanji Brown Jackson put forward was, and I'm quoting from her, she says, "I guess what I don't understand is how you can cut the state constitution out of the equation when it is giving the state legislature the authority to exercise legislative power." And I guess the conflict here is the state constitution the governing body when it comes to elections, or is the Constitution of the United States of America the power? And how do you square that circle for my viewers? Does the judiciary have the right to say to a legislature, what you have written here, this law, does not comport with our Constitution?
Certainly, one part of the respondent's argument, Ali, is that the state legislatures are creatures of the state constitutions, and therefore the federal Constitution in the Elections Clause takes the state legislatures as it finds them, namely as bound by the state constitutions. So that's how the respondents square the argument, and frankly, that's how I square the argument myself as well.
So what happens here? It seems to you, when I hear you talk about this, quite obvious. It seems when I listen to Neil Katyal or others, quite obvious. And yet the Supreme Court is considering this. There are 3 justices who appear prepared to accept the independent state legislature theory. There are 3 who appear not to accept it, and 3 where we don't have full information on where they're going to go on this. It is a little surprising. This is before the Supreme Court. What's the consequence of the Supreme Court allowing this to go through, allowing independent state legislature theory to become a real thing?
Ali, I understand the reaction of many that the court ought not even to be hearing this case but I disagree with that. We need to remember that the independent state legislature theory was the centerpiece of the efforts to overturn the 2020 election. In that situation, the issue arose in the context of the electors clause, not the elections clause, as in Moore versus Harper. But nonetheless, the Supreme Court had an obligation to decide this independent state legislature theory sooner rather than later. Arguably, it was obliged to decide the case in December of 2020 before January 6th. The court declined. There was never any question in anyone's mind who follows the court that the court would take the independent state legislature question at its first opportunity, and that turned out to be in Moore versus Harper in the context of the elections clause. It is almost impossible and perilous to attempt to divine what the individual justices, much less the entire court, is thinking. But as I said at the outset, in this case, because of the superior quality of the advocates before the court, both for the petitioners and for the respondents, and the fact that the court was well prepared, understanding the enormous importance of the case for American democracy, and finally the fact that the argument was 3 hours long. I believe that this is a circumstance where we can draw some at least tentative conclusions. For instance, I was left with the clear impression that the court as a whole has no appetite for the independent state legislature theory. Indeed, I believed that all 9 justices were clearly troubled about petitioners' novel idea of an independent state legislature, independent, that is, of the state Supreme Courts and the state constitutions. If the court does end up rejecting the independent state legislature theory, it may well still attempt to fashion a standard of review that would constrain the state Supreme Courts in their interpretations of the state constitutions. It would be fair, I think, to say that the court did not have any idea Wednesday as to what that standard might be. And frankly, neither did the advocates. There did seem to be a consensus in the courtroom, though, that the standard adopted by the court would have to be highly deferential to the state Supreme Courts and to their interpretations of their own state constitutions. I believe, Ali, that under any standard adopted, the court will affirm the decision of the North Carolina Supreme Court. As I've said, if for no other reason than that the North Carolina legislature legislated judicial review of its redistricting decisions by the courts under the state constitutions.
Well, when somebody as learned as you is optimistic about a potential outcome, so am I, because everything I know about this is from you. We appreciate the way you make this accessible. I don't know that my viewers necessarily make a point of following these court cases as they're going on, but this would be an important one to read up on so that when the results come out, when the decision is made, we understand the implications. Judge, it is always good to see you. Thank you, sir. We always appreciate your time.
Thank you, Alec.
Judge Michael Ludick is a former federal judge for the U.S. Court of Appeals for the Fourth Circuit.